So welcome, everybody, at the end of November. Hardy of you. I'm very pleased, very thrilled to be able to welcome and introduce Dr. Emma Cunliffe, who's coming to us all the way from BC, where she teaches in the law school. And as you probably read from the posters, Emma's area of expertise is in criminal law and evidence, and she has a fantastic book, Murder, Medicine, and Motherhood, recently published, and she's also working on a case examining child homicide, and also, very fortunately for us, working with Debra Parks, whose work people may also be familiar with, who's at the University of Manitoba, on this wonderful project on gender and wrongful convictions. And I also want to thank Richard, who also put Emma and I in touch and helped to coordinate Emma being able to come here and speak to us on a talk that I saw a little bit of in Vancouver, and I'm very excited to see more about. So I'll hand it over to Emma, and with our thanks.
Thank you, Amanda. And I should begin by saying thank you very much, Richard, for coordinating my visit and for putting me in touch with Amanda, and to Amanda for helping to sponsor me being out here. It's a real pleasure to be here to talk to you. And I will try to keep this informal and try to keep my remarks to about 40 minutes or so, hoping and expecting that you'll have lots of questions and looking forward to the discussion. But also, please don't hesitate to stop me as I go along if you do have any questions or anything that you'd like me to clarify. The other thing I should begin by saying is, as the slide behind me suggests, that Debra Parks is really the first author in the paper that I'm about to present today. And so while it's been very much a team effort, it begins from a paper that Debra actually presented at a conference in Berlin in 2007. And back at that time, she was thinking already about the question of women and wrongful convictions and how women might present different questions about the nature of the criminal justice system and the nature of truth and error in the criminal justice system. And the reason why that timing is interesting and important and speaks really to Debra's foresight is because in 2007, we had not yet seen the exonerations of women that have happened in Ontario since then. So for those of you who are familiar with the Gouge inquiry into paediatric forensic pathology and the exonerations of women such as Tammy Marcard that have happened since 2008, I think it's important to note and to give Debra credit for the fact that she was thinking about these questions long before they were on that radar. And so she's very much the driver for this paper, although I've tried where I can also to make contributions, of course. So let me talk a little bit then about the structure of my talk today. And it falls into four parts. The first is that I will give you a little bit more of a sense of the context, the ways in which both Debra and I come separately in some ways and in some ways together to this project where we're trying to unpack the relationships between women and wrongful convictions, and the context in which we are both doing this work. The second thing I'll do is give you the three key questions that we're really trying to answer in the work that we're doing together. I'll then focus on locating wrongful convictions, and that's not a self-evident title. What we really mean is that we've looked very hard at the Innocence Movement's work and the Innocence Project's work on wrongful conviction, and we're thinking about the values that work represents and the ways in which it may operate to exclude women's wrongful convictions from an accepted definition of wrongful conviction. And then the last part of the talk, I'm going to talk about a concept called taking responsibility. And that's the phrase that Debra and I have come up with to express something which we think is not exclusively feminine, but is perhaps a particularly feminine trait. And that is the idea that women, and particularly in relation to harms that take place within the family, may be socialised, may be particularly fast to take responsibility for the harms that come to those they love. And we think that that's an important strand in the wrongful convictions of women. So let's begin then with the context. So in the paper that forms the basis for today's talk, Debra and I explore what, both normatively and in practice, is included within the concept of wrongful convictions. And correspondingly, we seek to understand what kinds of cases don't qualify for that label. We're asking this question because as feminists who study the roles and experiences of women in criminal law, we've found ourselves wondering, where are the women in stories and reports of wrongful convictions? Certainly women are not entirely absent. In Australia, the UK and Canada, there are a few cases of women who were wrongly convicted of killing children in particular, and they loom large both in the academic literature and in the popular imagination. So at least 15 women have been wrongly convicted in Australia, Canada and the UK of killing children since 1980. Perhaps the paradigmatic example, at least for my generation, I'm interested to hear from you guys whether this remains true, is that of Lindy Chamberlain, who was convicted of killing her child in a circumstance where she said that the child was taken by a dingo. And so if you're a Simpsons fan, if you're a Seinfeld fan, this is a case that's been picked up and used as a meme, really, in popular culture and particularly sort of worked over by Hollywood. And it also forms the basis of a film which is called, I think, A Cry in the Dark here. In Australia, it's Evil Angels. But it's become a real sort of paradigmatic example of a mother who is wrongly convicted and, in fact, continues to be worked through. It was as late as 2012 that the last inquest was conducted into the child's death. But there are other cases that have attained sort of less attention. Tammy Marquardt, I've already mentioned here in Canada, who spent 14 years in jail before being exonerated in the death of her 3-year-old son. Angela Canning in the United Kingdom, together with Sally Clark, were both convicted of killing multiple infants in the late 1990s, early 2000s, and ultimately exonerated. But leaving those honourable exceptions to one side and noting as well that they are exceptional, that they're not the first examples that come to mind when we talk about wrongful conviction. When one reads the websites, the books and the other mainstream literature on wrongful convictions, the relative absence of women is striking. And we want to suggest that is so even accounting for the fact that women are charged and convicted of crime at far, and particularly serious violent crime, at far lower rates than men. Now, in fact, while women are comparatively statistically underrepresented among the ranks of those who commit serious violent crime, we argue in the paper that they are correspondingly overrepresented among the ranks of the wrongfully convicted. And so if one compares the proportion of women who are convicted of homicide with the proportion of exonerees who are women, you see that a disproportionate number of exonerees are women. And that's interesting because it doesn't really seem to have affected the ways in which we think about wrongful conviction. So we should say at the outset, I should say at the outset, that we don't wish to be understood to be arguing that there is a single or a simple woman question to be asked of these cases, or that we rely on some essential experience of female criminal defendants as a homogenous group. Volumes of feminist scholarship, particularly critical race feminism and feminist post-structural theory, have problematised the notion of an essential woman's experience in important ways and in ways that are very relevant to the populations that are affected by both being convicted of crime and being exonerated. There is clearly no one women's story of wrongful conviction. Nevertheless, we think it important and perhaps even indispensable to consider the role of gendered stereotypes alongside those of race and class stereotypes in widely shared conceptions of criminal guilt and in our beliefs about wrongful convictions. We should also say that very few or relatively few women seek review of their criminal convictions. For example, women have made up just 9 of the total of 225 applications for post-conviction review in Canada in the 11 years since the Criminal Conviction Review Group was instituted. So 9 of 225 is considerably less than 10%. In the cases that we have in mind in working on this paper, women have often taken responsibility on some level for what has happened, and particularly for a death that's occurred within their family. They may have pled guilty, they may have refused to testify, or they may have tried to avoid the prospect of their children having to testify or otherwise endure a trial. For many women, the wrongfulness of their conviction stems not from the reasons most often cited for the notorious wrongful convictions of men, and those reasons are things like police tunnel vision, jailhouse informants, faulty eyewitness testimony and the like, although we argue that women are of course also victims to these systemic errors. Instead, though, the errors that particularly affect women arise from more pervasive social inequalities, including, for example, the state's failure to provide real and lasting protection and safety for women who seek to leave abusive relationships. This article suggests that feminist and other critical interrogations of criminal law and procedure demand a broader concept of wrongful convictions. We begin with the focus of most scholarship on wrongful conviction as requiring demonstrable factual innocence, and suggest why this issue is problematic both for women and as a broader matter of criminal law principle. In the next part of the talk, I'll comment on the prevalence of women taking responsibility, primarily by pleading guilty, in homicide and intimate partner violence cases. I'll conclude by noting some of the potential implications of expanding our inquiry about wrongful convictions to take seriously the experiences of women. And so to summarise then, the key questions that we're asking in this research project are, first of all, what values drive the decision to label a case as a wrongful conviction? And here we're as interested in the work of the innocence movement as we are in the work of those who may be more institutionally entrenched, such as Justice Gouge in his inquiry here in Ontario. Secondly, we're keen to understand how well the experiences of women are reflected within these values, and correspondingly, of course, the extent to which they may be excluded. And finally, leading out of that second question, we're interested in understanding whether looking at women's cases in particular might serve to challenge received understandings of the causes of wrongful conviction. I'll come back to those causes a little bit. Okay, so let's talk about locating wrongful convictions. And here again, what we're looking to do is to think about how wrongful convictions are being understood both within the academic literature and in the popular imagination. And we begin with the proposition that the decision to define a case as a wrongful conviction or as a miscarriage of justice is value-laden. So a survey of the scholarship on wrongful convictions shows that the paradigmatic wrongly convicted defendant is demonstrably factually innocent. For example, the accused is proven not to have been present at the scene of the crime or was clearly not involved. And so you can see this classic definition. This article by Bordeaux and Radelet is widely regarded as having defined a field of scholarship, the field of innocence literature. And that use of the term innocence is quite strategic on the part of those who are part of the innocence movement. It's intended to focus popular and legal imagination on the possibility that a person who is wholly innocent, who had nothing to do with the crime, has found themselves in jail by virtue of an error that was made in the processing, the investigation or the prosecution of the crime. And so Bordeaux and Radelet explain, and they use here the term miscarriage of justice, which is actually in a sense even more interesting because that's the term that's more often seen as a broader term, that in their understanding, a miscarriage of justice doesn't arise if the accused, for instance, is found to have been denied access to a relevant legal defence or to have been involved in the offence in some way. So in talking about miscarriages of justice, Bordeaux and Radelet are only interested in wrong person errors, in the case where the wrong person has been convicted for a crime with which they had nothing whatsoever to do. This valorisation of demonstrable factual innocence has been reinforced and perhaps entrenched by the DNA exonerations that have formed the bread and butter in lots of ways of the innocence movement in the United States. And I should pause for a moment here to say that the mode in which I talk about the innocence movement, I consider myself part of the innocence movement, or at least part of a wrongful conviction movement. And so there's a wonderful line in one of Christine Boyle's early works where she says, the mode in which I'm speaking is not so much j'accuse as j'aime accuse. And I apologise for my appalling Australian accent, but what she means is that I'm not so much saying I accuse them as I accuse myself. And so really the mode in which we're talking about factual innocence in this project is to think about the ways in which that centripetal pull of an idea which has a great popular resonance might force us to overlook things that are also important. And I'll come back to that in questions if you're interested in it. But if one looks at the innocence literature, one of the things that you see is that the relative success of the DNA exoneration project has really driven a definition of factual innocence. And so The Innocence Project has accomplished an enormous amount in the face of enormous systemic inertia. There is a great deal of institutional investment in the soundness of the convictions that the criminal justice system secures. And the Innocence Project has, for example, at times encountered circumstances, and not just anomalous times, consistently, found that, for instance, prosecutors, when faced with a DNA exoneration, change the story of how the offence happened to create a new narrative that keeps the convicted offender somehow part of the picture. And so this is the stakes. These are the stakes, particularly in the American context, perhaps to a lesser extent here in that particular example. And that helps to explain why this focus on wrong person errors is so strong. And there's a sense, I think, too, in which there are so many battles to fight, these are at least somewhere we've got a fighting chance of winning. But what we're interested in is the consequences of that focus. So we suggest that the valorisation of demonstrable factual innocence can also be seen here in Canada. It's perhaps illustrated well in the discussion provided by the Honourable Antonio Lemaire, former Chief Justice of Canada, in his inquiry into 3 Newfoundland wrongful convictions. We'll focus here on Lemaire's characterisation of the accused in 2 of these cases, Gregory Parsons and Randy Druken. Lemaire characterised the 2 accused as follows. Gregory Parsons played no part whatsoever in the murder of his mother, Catherine Carroll. He's completely innocent. His innocence was established by DNA evidence. And alternatively, in relation to Druken, as you can see there on the screen, my mandate is not to retry Randy Druken, nor am I authorised to determine whether he is factually innocent. And what's really striking when you put these 2 quotes side by side, and they're not side by side in the report itself, is the way in which Parsons is wholly vindicated and becomes the victim of a terrible miscarriage, whereas he's much more mealy-mouthed, really, about Druken. And interestingly enough, I should explain that the possibility that Druken had any involvement in the crime of which he was convicted could not be investigated because police failed to collect and secure complete crime scene evidence after their investigation began to focus on Druken. So if it's not possible to exonerate Druken in terms of factual innocence, that lack of possibility comes about because of a failure in the investigation. Susan Bandes, who does a lot of work with the Innocence Project in the United States, has argued that the innocence movement has to complicate the simple stories offered by the DNA exoneration paradigm and find more nuanced ways to discuss state actors' responsibility for wrongful convictions. I've already alluded a little bit to some of the pressures that exist towards prioritising innocence, and I think Bandes is also sympathetic to these. The first is that we live in an era in which there is a considerable lack of sympathy for criminal defendants and a considerable othering of criminal defendants, and perhaps more so than was true, for example, in the 1960s. And one of the ways I try to sort of take my students through that when I teach criminal law is I look at popular depictions of criminality and criminal behaviour, and I look at the ways in which those depictions have been shifting over a 50-year period, and in particular the ways in which they've become more racialised in the United States. And so to the extent that one sees a glimmer or a glimpse of being on the outside of criminal justice today in popular culture, it tends to be in rap music, which is highly racialised. And it tends to be about that racialised experience of surveillance and enforcement. That wasn't true to the same extent in the 60s, although I don't mean to suggest that the 60s black defendants got an easier ride by any means, but rather actually what's happened is this narrowing of the focus of criminal law in a way that is highly racialised, that's highly classed, and perhaps is also gendered. The second thing is that there's a broad ambivalence about procedural protections, I think, in contemporary society. And it's interesting, I was talking about this to my evidence class the other day in the context of section 24.2 of the Charter, which is the provision of the Charter that provides an exclusionary remedy for evidence that's obtained in breach of a Charter right. And here in Canada, unlike in the States, you guys are not law students are you, so this probably warrants a little bit of description. Here in Canada, there's no automatic exclusion of evidence obtained in breach of the Charter. So in the States, once your rights have been breached, the evidence is out. Here, the court goes through a process of balancing the harm of the Charter breach against the state interest in the investigation and enforcement of crime.
The Section 1?
Section 24(2), actually. So it's a separate and very particular section which applies most often, not always, in the context of a criminal trial. And it's about executive action rather than legislative action. So it's about the action of police and prosecutors and people like that. So I said to my evidence class the other day, I think there's a real ambivalence about procedural protection, and somebody put up their hand and said, well, but hang on, the Charter is Canadians' revered and most favourite piece of legislation. To be fair, it was somebody who'd been out of the country a few years, and that may be a shifting thing. But I think that one of the really interesting things, and as an Australian who came as an adult to Canada, something that's very striking to me is the distinction that many Canadians hold between the values of the Charter and the ideal of the Charter and the point at which the rubber meets the road. And the point at which the rubber meets the road is the point at which the Supreme Court of Canada is trying to decide whether to exclude evidence that the police found 35 kilograms of cocaine in somebody's trunk, for example. And I think that it's fair to say that today, more so again than perhaps 20 years ago, there's a real popular ambivalence about the enforcement of constitutional rights resulting in the loss of a conviction in a case like that. And I think that the effect that has on the innocence movement is that this ambivalence about procedural rights creates a really strong incentive for the innocence movement to differentiate the people that they represent as being in no way involved with behaviour like that. Another interesting argument for innocence, which is made by Keith Findley, who's a professor at the University of Wisconsin in an article he published in 2011, is that it's important to try to obtain statistical validity in research about the causes and the contexts in which wrongful convictions happen. And so he says that failure to accord procedural rights has quite a different set of causal factors than wrong person errors. And he argues that in fact the benefit of prioritising innocence is that you're keeping two different types of error separate from one another. However, I think that there are also, and less well argued in the literature, some potentially invidious effects of prioritising innocence. The key one for Debra and I is that it undermines the importance and the unmovability, if I can coin a horrible neologism, of the state burden of proof. And so adversarial systems, the US, Canada, Australia, UK, are predicated on the principle that the state must prove criminal wrongdoing beyond a reasonable doubt while exercising the highest standards of probity. And it's this that potentially gets undermined by a focus on one type of error to the exclusion of others. And so under the paradigmatic model of a criminal trial, if an accused is acquitted, it may be because the Crown has failed to prove beyond a reasonable doubt that they committed the actus reus. It may be that a defence, such as the application of self-defence or insanity, or now called not criminally responsible by reason of mental disorder, is applied to that accused person. It might be because evidence was unconstitutionally obtained and has been excluded under the Charter remedy. The common law doesn't differentiate between sources of an acquittal. And I think that the danger of differentiating in the way in which we study these cases is that it makes some of those sources look more legitimate or more important than others. The second risk is that prioritising demonstrable innocence ghettoises defendants who can't prove factual innocence. And we'll come towards the end of my talk to some examples of the ways in which women might be particularly adversely affected by that. And so I want to suggest to you that by focusing on demonstrable factual innocence, we focus on cases in which, generally speaking, DNA evidence is available, and that tends to be rape and certain sorts of murder. And that tends to confine the the class of cases in which exoneration is available to a very particular type of crime. Now, it's good that we're using DNA evidence to that effect, but it's a problem when that becomes the only way in which somebody could be exonerated. And in particular, there's a possibility that some who are convicted do not have the same access to the type of evidence that might exonerate them as others do. The final risk of prioritising innocence and looking for causes such as false confessions, eyewitness identification, poor quality forensic science, is that it distracts from a discussion of root causes, and particularly from a discussion of the systemic implication of criminal justice processes, policing, the role of lawyers and judges in constructing wrongful convictions. So the prioritisation of demonstrable factual innocence serves an important rhetorical purpose for the innocence movement. There's no doubt about it. It enlists a moral consensus about who should not be subjected to criminal sanctions. The challenge, though, is that the standard of demonstrable factual innocence effectively focuses public attention on the risk that a real criminal remains undetected, often for a serious and violent crime. This appeal to the importance of catching the real offender establishes a model for wrongful convictions in which there's no doubt that there has been a crime, and the state desire to actually prosecute crime effectively is enlisted. However, if you think about it in those terms, then cases where there may have been no crime at all are excluded from the outset. And the key example of that is in the Gouge inquiry, in fact. And so a key aspect of the Gouge inquiry into child homicide cases here in Ontario was the finding that in most cases, in 18 of the 20 cases that Gouge looked at, there had been no crime at all. So the children had died naturally or accidentally, and those deaths had been wrongly attributed to homicide. This wasn't about getting the wrong perpetrator. It was about seeing a crime where no crime existed. Now, the reason why that's an issue that perhaps particularly affects women in an adverse way is because statistical studies of the wrongly convicted suggest that women are disproportionately represented among the ranks of those who are wrongly convicted of crimes that probably never occurred, particularly child abuse and homicide. Overwhelmingly, these women have been convicted for crimes against children. So Richard Leo, who is a absolutely central figure in the innocence movement, has argued that the focus on immediate causes such as eyewitness testimony or wrongful forensic science distracts from a more important, more pressing question, which is the theoretical, institutional and psychological root causes of wrongful conviction. And so his argument is that to the extent that there are systemic pressures, for example, to find a conviction in relation to a high-profile crime, systemic ways in which certain criminal justice system actors become socialised and oriented towards conviction in a way that tends to lead them to overlook disconfirming evidence, that the focus on things like eyewitness testimony and the quality of forensic science distracts from having a deeper conversation about the structural flaws of the criminal justice system. So the question that we think screams to be asked in the context of women and wrongful conviction, and which is not being asked, is why is it that women are disproportionately wrongly convicted of crimes against family members? To the extent that women are disproportionately numbered among the ranks of those who are wrongly convicted, the crimes they're wrongly convicted of are crimes against family members, both children and partners. And that's the question that I'll seek to answer in the second part of this talk. We think that the lack of focus on systemic and root causes and the overwhelming focus on wrong person errors is partly about an appeal by the innocence movement to a principle of rationality and self-interest which positions the criminal justice system as one which can be, with a bit of tweaking, a system which basically works pretty well to identify who's guilty of crimes and who's not. That things like the processes of fact determination and of police investigation are fundamentally sound, and that to the extent that errors happen, they happen because of failures that can be corrected in order to fix a system and get everything moving forward. Now, once you start to look at the crimes for which women are wrongly convicted, some of those assumptions can be challenged. In particular, if women are wrongly convicted of killing children and of killing partners, then the idea of a criminal action as a rational decision to break a law becomes a much more complicated one. Margaret Davies, I'll shift into kind of trying to explain this theoretical idea, which might be one that you've talked about a bit in your grad seminar. But Margaret Davies, who's a feminist theorist from Australia, describes the paradigmatic liberal actor as one who sees himself, and she uses the term carefully, as a free agent relating to a world of discernible analytical structures, and who thinks that this is the condition of everyone. In other words, the legal subject is one who understands the law, who chooses to do wrong knowing that they are doing wrong and having made a conscious choice to do so, in a context where they could have chosen otherwise. This legal subject is both constructed and protected by an account of criminal law as a tool that fosters personal autonomy by reinforcing responsibility on a case-by-case basis for presumptively choice-predicated actions. Wendy Brown has suggested that the autonomous liberal actor relies upon the subjection of women and is quite at odds historically with what men have wanted women to be, with what women were allowed to be, with what families have required of women, and with what women have socially been constructed to be. And so if one thinks about the locus of these wrongful convictions as being the family, Wendy Brown's point comes quite important, because the possibility that this is happening at a place where women are deeply socialised cannot be studied if you're thinking about eyewitness evidence or the failure of forensic science without thinking also about the context of women's lives. So the observation that liberal conceptions of autonomy actively exclude women from the outset has particular relevance for our concern about the criminal justice system's capacity to judge the actions of women as mothers, and particularly the actions of those women who've experienced domestic violence. As will become apparent, Debra and I believe that exploring the troubled relationship between liberal discourses of autonomy and choice and the relative rationality of fact-finding processes and criminalised women is crucial to understanding the wrongful convictions of women. Okay, so let's move then to this idea of taking responsibility. Sorry, I got out of whack there. Okay, there are two contexts in which Debra and I consider wrongful convictions are arising and are perhaps not being wholly identified. In some cases have been identified, but in both of these contexts that they present a real challenge to the innocence discourse. It's now known that both women and men may plead guilty when they are in fact innocent for a variety of reasons. In the Canadian child homicide cases reviewed by Justice Gouge, 7 accused pleaded guilty to child homicides that they did not commit, in circumstances where the children probably died naturally. And it's often remarked in the literature that the idea of pleading guilty, particularly to a crime as personal and as intimate as that, when you're not guilty, is one that's very difficult to understand. And I think the difficulty of understanding that speaks to why it can also be correspondingly difficult to have such a conviction reversed. So a majority of those who pleaded guilty when they weren't guilty in Ontario were women. Debra and I think that there may be different pressures on some women to plead guilty. So, for example, their primary responsibility for the care of children or other social and economic realities that they may face may come to bear on them in the criminal process in different ways. Equally, the experience that some poor and racialised women and men have with the police and other state officials may create particular pressures to plead guilty. We don't mean to suggest that all people who plead guilty under pressure are innocent, however that term might be defined. But what troubles us is the virtual absence of a discussion of differential pressures on variously situated suspects in the literature around identifying, correcting and preventing wrongful convictions, and particularly the relatively limited notion of false confessions that's generally employed within this literature. False confessions are most often understood to mean confessions that are coerced by illegal police interrogation tactics, and to exclude confessions that may be produced by social or ideological pressures to take responsibility for harms for which one may not be legally responsible. A key area we examine in the paper is women and homicide convictions. So studies of women who commit homicide identify that women are far less likely to commit homicide than men. The numbers in Canada are about 10% of those convicted. But when they do kill, they're overwhelmingly likely to kill family members. either intimate partners or children. The context in which the killing of intimate partners becomes particularly important in this context is women and self-defence. So the possibility that women occasionally kill in order to defend themselves from the abuse that they've suffered at the hands of an intimate partner. The child homicide context is one that we'll come back to. So you'll recall that Bedeau and Radelet's definition, which I put up at the start, said that they would exclude from the ranks of miscarriages of justice those who had been denied access to a legally available defence. That means that those women who kill in self-defence would be ineligible for consideration under this definition as having faced a miscarriage of justice. That definition has founded most of the Innocence projects that exist, including the Innocence project that exists at my school at UBC. I'm not sure about Alan Young's project here. But the consequence of that definition is that women have differential access to Innocence projects. Judge Lynn Ratushny in 1997 reviewed the convictions of women who had killed intimate partners and received life sentences. So a life sentence is only given to somebody who's either convicted of murder or the very, very, very serious manslaughter. Very few manslaughters receive a life sentence. It's almost unknown. So most of these women would have been convicted of murder. That carries the connotation that she intended to kill. Justice Ratushny recommended that the government review the convictions of 7 women who had received life sentences, but ultimately government changed and times changed and no women were released. Her review took place in the aftermath of a case called Lavallee, which you may have heard of, in which the Supreme Court of Canada recognised that the definition of self-defence, which had been adopted by Canadian courts until that point, excluded the experience of women who found themselves in a battering relationship. And in particular, that it had instantiated a paradigmatic idea about self-defence, which was that of the kind of pub fight between 2 approximately equal physical adversaries. In Lavallee, the court held that a woman who finds herself in a battering relationship may be unable to leave the violence for a variety of reasons, from the psychological effects of the trauma of the battering to the physical, to the social and economic context, that she may simply not have the money, and that in many communities, particularly many small communities, shelters and refuges are not readily available to provide housing to women and children leaving abusive relationships. So Judge Ratushny was asked to review convictions that had taken place before Lavallee to see whether women may have been denied access to this defence. The key thing that I want to pull from her report, she sat down and spoke to 96 women who'd been convicted in this context, and she found that these women faced different circumstances in the way in which their crimes were investigated, in their decisions to plead guilty in many cases guilty to murder. She held that she found that there may be additional factors that exert even more pressure than is usually placed on a criminal accused to plead guilty. The fact that she may have a young family to care for, that she may have been a victim of abuse and is reluctant to testify publicly about the abuse. And this is something that's been written about a great deal in sexual assault as well. The question of asking a woman to testify about the most personal, most humiliating, most difficult experiences of her life in the context of a courtroom. She may be genuinely remorseful. And even though she feels like she had to act to defend herself, she has difficulty justifying taking another person's life. And so there's been a great deal of research into the complexity of the relationship between women and their battering spouses and the ways in which love is a big part of that relationship. And so a woman who has killed a partner may well feel truly guilty for that, even in a context that the Supreme Court of Canada might recognise as self-defence. For a woman in this situation, the forces impelling her to plead guilty are considerable. So at virtually all stages of her review, Judge Ratushny encountered substantial opposition to the self-defence review, both from provincial prosecutors who had a real problem with a judge second-guessing their convictions, that's how they described them, as well as from those who rejected the very idea of a review of women's cases only. The opposition reveals the strong pull of gender neutrality in the law, as well as the strength of resistance to a potentially broader notion of innocence that was implicit in the SDR, and this notion of innocence again cuts across much of the innocence discourse. Okay, given time, I'm going to skip past the discussion of Sheehy and Jennifer Dick's research, but I'd be happy to come back to that in questions. But I'd like to talk a little bit about the women and child homicide, because this is the context that's closest to my own research, and this is the context with which I'm most familiar. So I found in 2009, having conducted a survey of all cases in which women were charged with killing children, that women are increasingly being charged with murder rather than a lesser included offence such as infanticide or manslaughter. And so there seems to have been a conscious decision on the part of Crown prosecutors that when a woman kills a child, they will lay the most serious charge. And so to give you some sense of the numbers there, prior to 2000, from 1954 when the infanticide offence was first put into the criminal code, from 1954 to 1990, no woman was ever charged with murder. And that may be a problem too. I don't wish to defend that statistic. But interestingly, from 2000 to 2009, I found 10 cases, and in every one of those cases, the woman had been charged with murder. And in very few of those cases was the woman ultimately convicted of murder. Ultimately, the court saw the correct conviction either as infanticide or as manslaughter in most of those cases. In the work that I'm doing now, and which will form the basis of a book that I'm in the process of writing, I've found considerable similarities between those women who were wrongly convicted and who form the basis of the Gouge inquiry, and cases prosecuted in Canada at about the same time that haven't been challenged. And so there are two particular places where I see these similarities as playing out in important ways. The first is in the ways in which police interview women. It's very clear that when faced with a suspicious child death and when the mother is the suspect, the police use her relationship with the child, her sense of responsibility for the child and her guilt about the child's death as a way, as a moral lever to get the mother to not just confess to performing an action which may have killed the child, but to take full responsibility in the sense of the intentionality required for murder. It's a very clear, very deliberate police strategy which is used both in wrongful convictions, which have resulted in guilty pleas, and in cases that are considered to be sound. In relation to forensic medicine, much of the problems that Justice Gouge identified with Charles Smith's testimony in the child homicide cases are also apparent in trial transcripts of women prosecuted in other provinces at about the same time involving other pathologists and paediatricians. And so the lack of attention to the limits of research, the cavalier adoption of stereotypes about what sorts of families experience homicide, the lack of careful attention to physical signs of homicide in the context where the police have behavioural reason to think that there might be a murder. All of these things are present in Manitoba, they're present in Saskatchewan, they're present in Nova Scotia and in BC, and they haven't been reviewed. And that underscores one of Debra and my key conclusions, which is that there may be more similarity between the cases of women who are rightly convicted and the cases of women who are wrongly convicted than there are between women as a general population and men as a general population of criminal defendants. And again, I want to be clear that I'm not claiming by that women have been, in a sense, disproportionately victimised in any sense, or that there are not also problems with the ways in which the criminal justice system operates in relation to men, and I would say especially Aboriginal men. But that women are treated differently at every stage of the process, and that those differences are more apparent when you look sort of across both rightful and wrongful convictions. The role of implicit prejudice. Implicit prejudice is defined by psychologists and has been extensively studied. Have any of you taken the Harvard Implicit Association test? Okay, it's fascinating and well worth doing. Essentially, a bunch of really smart people have come up with a way of testing the extent to which we carry with us negative connotations in relation to for example, women or Black Americans. to a greater extent than we do in relation to men or white Americans. And it's all based on a computer and how quickly you answer certain questions when certain categories are placed together. And they've now tested more than 1 million people. What they've found is that implicit prejudice is uncontrolled, and that the person who suffers from implicit prejudice, which is pretty much all of us, are unaware of the fact that we carry that implicit prejudice with us. It's disconnected wholly from the explicit attitudes that one seeks to adopt. And so this is what's really frightening, frankly, about these research findings, is that even where one seeks consciously to decolonise one's thoughts, to adopt anti-racist attitudes, implicit prejudice can undermine that. So I think that that's particularly important in relation to the criminal justice system, and especially in light of findings that there are certain groups who are disproportionately likely to be wrongly convicted. So in America, that certainly includes Black Americans. Here it includes Aboriginal Canadians. I would argue, Debra would argue, and the statistics back us up on this, that it also includes women in relation to certain types of crimes. We think that it's hugely important to think about the potential role of implicit prejudice and stereotypes about how crime happens in explaining how those wrongful convictions come to pass. And again, that's a focus which isn't really permitted by the emphasis on factual innocence. The last point, and it resonates very much with Judge Ratushni's finding in relation to self-defence, is the prevalence of mothers who seek to take responsibility for what has happened to their children. So who, when a child dies, express anxiety about whether it was their actions that caused the child's death. And on probing, often they explain, we're not talking about causal in the sense of I killed the child, but I mean that I shouted at her the morning that she died. I mean that I had an argument with my husband that day. I mean that I couldn't afford to move her out of the mouldy basement apartment, and I really wish we could have done that. And in fact, studies of infant death and grieving show that that sort of self-blame is ubiquitous. The distinction between men and women, interestingly, is not that they blame themselves differently, but that they express that blame differently. So women are more likely to express self-blame than men are, and so that's an interesting thing in terms of the vulnerability of women to be wrongly convicted in relation to these crimes, because certainly one of the things that I've found is that in a context where a mother does, in some sense, take responsibility for having performed an action or failed to do something that might have led to the child's death, police are deflected from, and the prosecutor is deflected from, a thorough working up of the forensic medicine and the forensic science investigation in relation to how the child died by that admission of responsibility. So what actually happens is once a mother says, yes, I did this and I think it might have hurt the child, they stop looking. And that's a huge problem in terms of the possibility that in fact the mother's just blaming herself. And the way in which it's gendered is that women are more likely to say so, even if men also experience those feelings. Okay, so the implications of the work that Debra and I are doing. First of all, unfortunately, it means that wrongful convictions are not easily remedied and not easily avoided. There are no neat categories. Eyewitness identification and poor quality forensic science are important problems. They deserve to be worked on. But what we shouldn't do is make ourselves the illusory promise that if we can fix those problems, we'll fix the criminal justice system. We think the problems are deeper and more systemic than that would suggest. A second implication is that the state is implicated much more broadly than just in relation to the police function of investigating crime and the prosecutorial function of carrying a case through a trial. The failure to protect women and children from domestic violence leads potentially to wrongful convictions in the self-defence context. State actions which are predicated on stereotype and implicit prejudice lead potentially to wrongful convictions in terms of who attracts attention, how close scrutiny they receive, and what happens when a child dies. And the final implication, and I think again this is in the spirit of J'aime accuse, is the need to accept the challenge of occasionally telling complicated stories, whether that is in relation to legal cases or whether that's to the media. But I think that these conclusions, or the findings that I've sort of taken you through, show why it might be hugely important at times to sit down and seek to educate one's audience about the importance of procedural protections and about why they shouldn't be undermined by a focus on factual innocence. So I'm happy to take your questions, and thank you for your attention.
Fantastic. And I'm sorry, I should have said at the beginning that I also wanted to thank Criminology and the Institute of Feminist Legal Studies for co-sponsoring this event. So I'm sorry
Me
for not
too.
having said that at the beginning. And thank you, that was fulsome, and I'm sure gave people lots to think about, lots perhaps to comment on. So I will keep a speaker's list. Jason, start with that.
Please, can you use a microphone?
Oh, right, sorry. Yeah, a little intimidating.
Hello? I don't know if it's on.
Is that fine?
Yeah.
Yeah.
Okay. Well, so from your last slide, you talked about how the state is implicated more broadly.
Yes.
What kind of measures can we implement, or suggestions you have for the reform of the criminal justice system in order to protect women and children from domestic violence?
That's a huge question.
I know. Just a few little...
No kidding. Yeah. I think in a sense, Jason, my answer begins with what I see as a potential disconnect between where your question starts and where it finishes. And so you start with what reforms would I recommend, and then to the criminal justice system. And in a sense, I sort of feel like by the time we're at the criminal justice system, the battle's been lost. And that's perhaps the biggest takeout from the work that I try to do, and I think also from the work that Debra Parks tries to do. At the point at which a woman kills her partner to escape violence, there have been so many failures along the way. Likewise, at the point at which a child dies of natural causes in a mouldy basement, there have been so many failures in relation to that child that I would much prefer that we spend the sort of policy dollars and intellect that we devote to law and order politics and the criminal justice system, and how do we find and lock up criminals and keep them locked up for as long as possible. If we took a tenth of that budget and thought about how we could support women and families in building better lives for themselves, then I think that we'd see an enormous benefit. Part of the problem with that, of course, is that the benefits that you do see, you don't see in an election cycle. You see them in 15 or 18 or 20 years, and that's a difficult sell. Nonetheless, I think it's one that requires a bit of guts, really, and a willingness to commit to.
Thank you.
Okay, so I've got Fatima, and then I've got Faye, and so please do talk into the microphones because we're recording this, and so that's why. It's not meant to intimidate. But if it does intimidate and you want to write your question down and pass it up, you can do that as well.
Hi, my question was mostly basic question, asking you what methods you use for your research, and I'm pretty sure you mentioned some of the challenges that you faced during conducting this research. What other challenges were throughout the research that you faced?
Yeah, I'm absolutely happy to talk about that a little bit, and I'll try not to go on as I'm a bit of a methods geek. Amanda, I'm also assuming that you'll take time from now on and let me know when
yes, absolutely.
Yeah, great. This piece that Debra and I are writing together, I mentioned at the outset, is one that comes from kind of two, not entirely parallel by any means. We've been good friends and collaborators for a long time, but two separate lines of research. And so I'll speak to mine more than I will to Debra's. In my work, I spend a great deal of time focusing on the court records of cases that I'm interested in, and so here in the context in which I'm talking today, child homicide cases. And so I've reviewed the trial transcripts, the expert reports for now 22 child homicide cases in Canada, as well as 5 in the UK and 3 in Australia. If you've never encountered a court record for a complicated or a contested criminal case, they can be 20 to 100,000 pages long. They're very unwieldy kind of institutional archives, but in a sense that's the fun of it too, is that they're so remarkable in what they contain. And so, for example, a criminal transcript contains every word spoken by an authorised actor during a trial. One of the challenges of having an archive as rich as that is it can be seductive. You think you know everything. And of course, you can never know everything. So I was careful to say every word spoken by an authorised actor, not by any means every word spoken in that courtroom, for example. Equally, I published a piece way back in 2006 in the Australian Feminist Law Journal that talked about the seductiveness of believing you understand the subjectivity of those you study by virtue of what they say when they're in the courtroom. And of course, that can't possibly be true. And so all I can ever understand really is that part of themselves that people choose and are able to put forward in that extremely intimidating, extremely unusual context of the courtroom. The second thing that I do, particularly in relation to forensic medicine, which is a key research interest of mine, is I take the testimony given by experts at trial and I compare it directly with the peer-reviewed medical literature in their field. And so that can be time consuming. So for example, tomorrow I'm speaking downtown about shaken baby syndrome. And there have been about 1,600 articles published on shaken baby syndrome since 1932. But nonetheless, I think it's the best possible way to get a sense of the consensus within a community according to its own terms. I mean, there are all sorts of problems with the peer review process, but at the very least, you can say that the things that have gotten through the peer review process have been looked at by others in the same field. And one of the remarkable things that methodology allows me to do of comparing what's in that peer-reviewed literature with what they say when they come to court is it allows me to show how much less careful experts are when they testify in court than when they write. And that, when I do a little bit of work teaching judges, and when I tell my judges about my findings in that regard, they're absolutely horrified because, of course, to me as a lawyer, to them as a judge, they believe that a criminal trial where somebody stands in Canada potentially to face a life sentence should be, you know, the most careful, most rigorous moment of all possible times for one's research. And yet what you see, and not just with Charles Smith, I should emphasise this, is that those people who are very careful in their research to explain the limits of their findings, to explain unknowns and places where there's still work to be done, come into court, and very often the adversarial process seems to push them to a position of hardening their views. And so rather than explaining that this is the best knowledge we have right now, but this is the research context in which that comes, they'll simply say, no, it's possible for us to conclude that this child was killed. And these are the symptoms. And to the extent that they do refer explicitly to the literature, interestingly, one of the findings I make in Murder, Medicine and Motherhood, which is the book I published a couple of years ago, is that serves as a rhetorical device to enlist the consensus of a medical community rather than as an accurate depiction of the state of knowledge in the published medical research. So interestingly, they do sometimes say, look, the literature says X, but it often says X and Y and with Z limitation, none of which comes through. And so interestingly enough, courts think they're getting a window into a field of medical research, but really they're not. Really the work that experts are doing in court is quite different from the work they do in their research, and that's something that's come straight from my method.
This is also a methods question.
Sure.
You discuss systemic factors that inform women's choice to take responsibility.
Yes.
I'm wondering if we have methods to, say, look at women's socialization into this process and what that method would look like and how it's used.
Yeah, those are great questions, and in a sense, questions perhaps better answered by a behavioural scientist than a lawyer. But I'll do my best with that with that caveat very much in mind. I think that it is tools like the implicit association test that carry enormous power in relation to understanding how it is that we might internalise and read particular subject positions quite differently from one another. And so, for example, one of the nuances of the implicit association test that I haven't been able to sort of articulate in the talk is that they find that the negative connotations of, for example, women are different from, and they arise in different places than the negative connotations in relation to Black Americans. So in other words, while there are hierarchies, those hierarchies operate differently, and of course, therefore, Black women may be read differently again. So that's one piece, but it's an indirect piece. A second thing that the psychologists are sort of increasingly good at, I think, is designing studies, whether they're kind of vignettes with potential jurors, that seek to understand how some of these more theoretical ideas that are coming out of things like the implicit association test might play into something that comes closer to a more realistic social or legal context. And so for instance, they do very careful research design with what they call stepwise analysis, where they give different groups who are sort of demographically similar scenarios that are different in, for example, they give a father to one group and a mother to one group and see what plays out in relation to that. But I mean, your question was really more about the internalisation of those stereotypes. It's a complicated one to get at, but there's a whole field, I guess, of gender studies and behavioural science that seeks to get at it.
Yeah, because I'm interested in how, when you bring this into the courtroom setting, how you would go about teasing out these factors that influence and inform women's decisions, which I think are extremely important to consider.
Yeah, and it's good to know that that's the context in which you're asking the question, because that's a question I'm much better qualified to answer, actually. So yay. So another of the things that I found in Murder, Medicine and Motherhood is that when a woman is charged with a crime, such as a child homicide, well, specifically when a mother's charged with child homicide, a much narrower and more punitive vision of motherhood is imposed in the trial context than may be true in society at large. And I think this speaks to the importance of what the psychologists call framing. So actions that would be seen as innocuous if they were performed by our friends suddenly become suspicious because the child has died, because the mother is charged with her murder. And so that framing changes how we see things that we might be quite happy to accept in other contexts. Now, in Murder, Medicine and Motherhood, I argue that too often defence counsel accept that framing. And so to give you an example from one of the cases I've looked at, rather than, so this is the case of Kathleen Folbig, which is a mother who I argue was wrongly convicted, who's still in prison in Australia. She was convicted of killing 4 children who died over the course of a decade. And the Crown prosecutor, who was a man called Mark Tedeschi, who's actually been implicated in a number of wrongful convictions of women, potential wrongful convictions of women, none of them have been reversed yet, made the argument that she killed the children because she was essentially selfish, because she liked to go to the gym and she liked to go out dancing with her friends, and the children got in the way. And I mean, even as I sit here I have real trouble doing justice to that argument, because I have real trouble believing that could possibly ever be a reason. I mean, and I should be clear, some women kill their children for reasons that are complicated and difficult to understand, but I have trouble accepting that as a reason why you would kill your children, but it was very much presented in that way. The defence, rather than sort of saying, did she not maybe just want to have a night off every now and then, and maybe want her husband to do the washing up sometimes, and maybe want to have a part-time job because she wanted to contribute to the family's finances and they weren't very well off. Sort of said, no, that wasn't her true desires at all. What she really wanted was to stay home with the children, to be an excellent, outstanding mother at all possible times. And the jury, I speculate, looked at her and said that doesn't fit. It doesn't fit with our sense of who she is. And unfortunately, that defence strategy, I worry, made her more suspicious, much more so than if the defence had said, yes, she was a normal mother. There were times when she wanted a break. There were times when she was grumpy with her husband because he wouldn't do the washing up. Which of us has not found ourselves there? And don't use the fact that 4 children have died here to make that essentially innocuous, enormously usual quotidian experience into something it's not. And so one of the ways that I try to make that argument in a more kind of theoretically sophisticated way is a thing called the base rate fallacy. And so the base rate fallacy is the idea that once a stereotype is activated, that we ignore the most likely explanation. And so, for example, if we can say that most parents are sleep deprived at some time, but very few children die, then we might see evidence that a mother was sleep deprived and grumpy quite differently than if we say her child died and she was grumpy because she was sleep deprived and that's why she killed them, right? And so it's partly about kind of shifting the frame, I think. And too often defence counsel accept the frame.
No, that's really helpful. Thank you.
Cool.
Thinking. Someone. I mean, I can go ahead if it's my turn. Oh, Richard.
Sorry. I have to say I found it fascinating and it's kind of mind-blowing. I guess I'd have to accuse myself or charge myself as being also a defender subscribing to the narrow definition in my own writings, etc. So I guess this is a nice corrective for me. I'd just like to make clear what the differences between the sort of the factual innocence criterion, and my understanding of what you're saying is that you're suggesting that we broaden the notion of wrongful conviction to include those cases in which there were defenses available that were never explored, partly because of restrictions in cultural narratives that are available on the basis of gender and so forth, et cetera. Those would also qualify as wrongful convictions, which is not consistent with the legal understanding of what a wrongful conviction is. It introduces other considerations, more sociological. Okay.
Yeah.
Do I vaguely understand? Am I sort of on the right?
No, I totally understand,
Yeah,
Richard,
yeah.
and I'm trying to think about sort of how far I agree with you and at what point I
Yeah.
start to disagree and how
Sure,
to
yeah,
articulate
sure.
that, because I think
Yeah.
both are true. Yes, I certainly would broaden the concept of wrongful conviction to include a defence which was not accessed at the time of trial, or which was not understood at the time of trial, potentially. I mean, the Ratushny example, in some cases those women made those arguments and were not heard because it was pre-Lavallee. I'm not at all sure. I mean, a judgment I keep coming back to is the Ontario Court of Appeals judgment in Mullins-Johnson. William Mullins-Johnson, who was an Aboriginal Canadian man who was wrongly convicted of first-degree murder in relation to the death of his niece, based on very, very bad pathology evidence given, among others, by Charles Smith, not only by Charles Smith. He requested that the Ontario Court of Appeal declare him factually innocent. And Justice Rosenberg, writing on behalf of the court, refused to do that and said that the law doesn't recognise a category of factual innocence. It simply recognises guilt or non-guilt. And so it's then followed by a line which says, in the eyes of the law, Mr. Mullins-Johnson is innocent. And so I think that's the line I'm trying to walk, is that there is guilty and then there's everything else. And the everything else shouldn't, at least in terms of talking about moral claim to correction of error, shouldn't be further differentiated. So there are other reasons to differentiate. Obviously, one must make arguments based on the case in front of you. But that I'm very worried by a claim, for example, that some types of error deserve priority over other types of error. That error which can be demonstrably, which is about demonstrated factual innocence, should be prioritised and is being systemically prioritised now by innocence movements over other types of error. And so to give you another example, and I think to come back to this idea about crimes that never happened, I think that it is analytically, epistemologically, challenging at best, and perhaps, I was going to say a fool's errand, but that's a bit strong, impossible at worst, to distinguish between those cases where we know what happened and those cases where the state's case, based on a second look, was not good enough. And so, for example, I resist a reading which differentiates, for example, those exonerees from the Smith cases, which were exonerated because we don't now know how this child died, should not be systematically separated from those who were exonerated because we now can prove the child died naturally. Because I think that if there's a failure there, it's a failure in our understanding about how kids die. It's not a failure of the defendant.
You know, it seems to me, Emma, that what you're saying then is part of what you could broaden wrongful conviction to include those cases where the prosecution really did not mount an effective case for conviction on the basis of jumping the gun or prejudices or preconceived notions, or that the lawyering was insufficient.
Yes.
So that leads me to the question. You talk about women as a sort of a unified category. I mean, a lot of the literature suggests that there's a class consideration as well in terms of the susceptibility to these kinds of, like poor lawyering or easy prosecution and so forth. So how does that break down? Would you say that is there a kind of a greater likelihood that women who are poor are more likely to fall into these categories? And I guess with your notion of wrongful conviction, it would also increase the number of males who've been wrongfully convicted as well.
Yeah. Yeah,
okay,
yeah, indeed. So I'll address the second part of the question first and then come back, because I can do that quickly. Yes, it does. And in fact, the whole premise of this paper is that this is not just a woman problem. Actually, it's rather that standing in that place allows you to see important things about the innocence movement as a whole that have important implications for men's cases as well. It just happens that this is a class of or a group of cases that let us see that in a way. But to return to I'm worried now, and I'll have to go back and look more carefully, Richard. I began by suggesting that we don't see there as being a single woman question, and in fact we're seeking to resist that sort of essentialising. And I think that's an important thing to reinforce at this point in our discussion. By no means do I see women defendants or those who may be suspected of crime as an undifferentiated group. Interestingly, that plays out in the child homicide cases that I understand best. That plays out in really interestingly different ways in the 4 jurisdictions with which I'm most familiar. So that's Canada, the US, the UK and Australia. Here in Canada, those women who've been wrongly convicted are disproportionately welfare dependent, disproportionately either not in a relationship or in a relationship with somebody who was not the biological father of their children, which certainly seems to have been important in terms of how those women were read. They're disproportionately immigrant or Aboriginal, and they're disproportionately likely to have a history themselves of having been subject to to CAS involvement with themselves as kids, or to have had some of that in relation to their kids during the kid's life. All of those factors are hugely important to understanding why they became the object of suspicion, and to understanding why the cases played out as they did. Interestingly enough, that does not hold for the UK and for Australia. And so the victims of wrongful convictions, Sally Clark, Angela Cannings, Trupti Patel, Donna Anthony, Kathleen Folbig, I argue, Carol Matthey and Tracy Phillips in the UK and Australia were, by most measures, middle class. They weren't necessarily wealthy by any means, but they were in stable relationships with the man who was the father of their children. There was an income in the house. Tracy Phillips was Aboriginal, but she's the only one of that group who were, Tripti Patel was East Indian, but who were racialised in particular ways. So the cases there, which were predicated on a very different kind of a mistake, actually. They were predicated on disbelieving the possibility of multiple child deaths in a given family. That seemed to drive through class in a really interesting way. So Sally Clark was a solicitor. Angela Cannings was a pharmacist. The American cases are different again. There was a study of 42 wrongful convictions of women and comparing them to wrongly convicted men in America. They found that white women were disproportionately likely to be convicted wrongly of child abuse, and black women were disproportionately likely to be wrongly convicted of murder in America. And so that led the authors of that study, Rusnick and Free, to suggest that obviously there is some differential in terms of how stereotypes are being read in those cases as well. So yeah, far from a unified group, and I'm sorry if I suggested otherwise. Yeah.
yet? Have you? No. Okay, Jason again. Sorry, no, not.
So yeah, you kind of showed that there are like procedural problems in the courts, especially around expert testimony, and you explained that it was hard to kind of gain access to how the courts are treating those expert testimony, right? So do you have any suggestions on how to balance the need to get more access to these procedures while minimizing, the harms associated with public access to the courts?
Access. In fact, this is something I've published on. Here in Canada, we have quite a strong protection of what's called the principle of open justice. I argue it's several principles, but a key aspect of those principles is the idea that court should be an open process, and it should be open to research and study and, for example, to the media. Here in Canada, the reason why it's strongly protected is it's seen as an incidence of the protection of the freedom of expression under Section 2B of the Charter, which can only be limited according to Section 1. Or at times there'll be a contest between the Section 2B freedom of expression and, for example, an accused person's fair trial rights. And in that case, there's a case called Dagonet that the court explains how to balance or kind of try to steer a path through those competing rights. So actually, one of the nice things about working in Canada is that access is readily available and is very good. So the transcripts the quality of transcripts are reasonably high. And I argue that the paper I wrote compares Canada favourably to Australia unfavourably in that regard. So Australia has no Charter of Rights and Freedoms, and it's much harder to get access to this stuff in Australian courts. And so the argument I make is that actually an important potential source of oversight of what courts do is academic study. And that while open justice is most often talked about, and I mean, we're seeing this play out with Rob Ford, we're seeing this play out with Mike Duffy, in relation to kind of the media and the media's right to tell the public what they want to know or believe they have, some prurient interest in knowing. That academic inquiry is also actually a really important reason to protect open justice, because it allows this sort of research to happen. But certainly without that sort of access, it wouldn't be possible for me to reach the conclusions I do. Yeah.
But the Canadian system is satisfactory?
Canadian's pretty good, but it takes a long time, and it's expensive. Those are the two big things. So it's okay for me now that I'm an academic, but when I was a grad student, paying $1 a page to photocopy was a hard thing to do. Yeah.
Thanks.
Any other questions? We are coming close to 4 o'clock, so we have one more. Okay, then please join me in thanking and also